na 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 na. Bam bam. Oh na 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 na. Bam bam. Oh na 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 na. Bam bam. Oh na 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 na. Big it up. Oh na 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 na. Big it up. Oh na 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 na. Bam bam. Ba 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 de. Ba ba ba. Ba ba mi de. Ba 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 mi de. Ba ba ba.
Welcome to Home and Away Jamaica. I am your host, Paulette Price, and today's show will be with me and my co-host, Robert Taylor. Today, we want to talk about leases. And you might think it's just a regular document, but when something goes wrong, we realize the importance. And the reason why we're going to talk about leases today is because if you listened into some of the other programs, you will see why one type of lease makes such a big difference to how things turn out if something goes wrong. And as they say, always have an agreement before you fall out, because when you've fallen out, you can't put it right. So today, my co-host is our special guest. And so I am going to be asking Robert all the questions today. So Robert, as everybody knows, I'm a real estate agent. So when I'm doing a rental, I give a client a lease agreement, which is obviously being looked over by an attorney. So the prospective tenant will look at that lease and not always sure if they should accept everything. But what I think you could probably start off with is just telling us what are the important and basic things that should be in a lease agreement, a rental lease agreement.
Sure, Paulette. So what you describe is the typical situation where a landlord may have an attorney prepare a lease or may, pull or extract a lease online. And that lease is given in hard copy to the tenant who, in most instances, really doesn't have the wherewithal to understand the implications of some of the terms in that lease, may not consider it important at that time, and will sign the lease. And then at some point during the term of the lease, if for some reason a conflict arises, it's only then that there is some real determination that a particular provision was unfavorable. And so what I will do is share with our listeners and our viewers some of the clauses that are important to both parties, not just the landlord, but also the tenant. And
right.
I think one of the first things we need to understand is that in law, we have leasehold interests and freehold interests. And so if you own property, you're the registered title owner, you have a freehold interest. If you're leasing property from a landlord, you have a leasehold interest. Your leasehold interest during the term of your lease is just as equivalent as your freehold interest. And so effectively what happens, the rights that a title holder has during the term of the lease is suspended. All those rights are transferred to the tenant. And so it's important that tenants understand that very simple concept. During the time you're in possession, you have the rights and interest in that property. And so what the lease does is try to clarify and explain the boundaries of those rights and interests. So that's the first point I want to make.
Right.
The second point, and I think, Paulette, you would handle much of this in your own due diligence, but we want to make sure that the person who is leasing the premises is the title holder. They are the person that owns a property.
Yeah.
And so one of the first things we want to see in the lease is the ownership. And typically this is put in a schedule to the lease. The schedule comes at the back. And also we want a description of the property so that we are absolutely sure that the property that you're renting is actually the description, the legal description matches the location. So that's the first thing. Well, that's the second thing. We also want to make sure that the lease mentions both parties by name, the lessor, who is the person leasing the premises, and the lessee, who is the person renting and coming into occupation. The lease is a contract, so it must have all the elements of a contract. So the parties have to be named. We need to have the consideration, that is a rent. What is a monthly rent? And we also want to know the term of the lease. Is the lease for a year? Is it 2 years, 3 years, 4 years? The term needs to be specified. And that's absolutely important, because when the term ends, then the lease will speak to how possession is given up, or if the lessee remains in possession after that expiry period. So those are some important elements that we want to include in the contract. Any questions at this stage, Paulette, or you want me to continue?
No, definitely continue. Yeah, continue.
Right. So we've identified the parties, and then one of the first things we want to speak to is the rent, the frequency of the payment, whether it's paid in advance. Typically it's paid in advance. So we must state the day in the month, generally, and most typically the first day of the month. We also want to speak to the deposit. And so it is very typical and conventional in rental agreements that the landlord will want to take a deposit. The convention in Jamaica is 2 months deposit, or 2 months deposit equivalent to 2 months rent. And that deposit, and we discussed this in our last program with the Rent Assessment Board, is really not for unpaid rent. It's not a reserve that the tenant can rely on to use to set off rent. It really is a reserve that's set aside for the landlord at completion of a tenancy to utilize in the event there's a need for any repairs. If for some reason the tenant has left the property in disrepair, then the landlord has the benefit of this deposit to make good any defects that may have been the result of the tenant's occupation. So we'll have the security deposit. The lease will speak to the security deposit. What we also want to do is recognize the responsibilities of both parties. So
Right.
leases will generally have the tenant's covenants separated from the landlord's covenants, which effectively is the obligation on both parties. And so we'll generally speak to the covenants or the obligations of the tenant, which is to pay rent on time. The parties may agree that the rent must be paid in cash, or it may be paid to the bank, and the appropriate instructions given for the payment of the rent to the bank. That the tenant will pay utilities, will pay telephone. We don't really have much of that as we now move to mobile phones, but electricity, and in particular water. Water is very tricky in that unpaid water can create issues, and water moves with the land. What we mean by that is, regardless of who is the tenant, if there is unpaid water, the water utility company will not reconnect water where there is a past due bill of a previous occupant. So it's very important that water is paid. There's also the obligation of the tenant to keep the property in good repair and condition. And also with that, there's generally an obligation for the tenant to pay any maintenance that may be required over a certain amount. A landlord may say, I will pay for any defects, rather up to a certain amount. So anything over $1,000 or $10,000 will be my responsibility, but minor repairs are for the tenant's account. It's also important, and I mentioned this in opening, that the landlord may need permission to inspect the premises because the landlord's tenancy is suspended during the lease. So the landlord really has no authority to enter that premises or property without permission. And so the lease generally and should include a provision that allows the landlord, with proper notice to the tenant, the ability to enter either for repairs or, for example, let's say the landlord's selling the property, then he or she may need to show the property to a prospective purchaser. The lease should speak to the notice period that the landlord has to give to the tenant for gaining entry to the property. This lease should also speak to the fact that the tenant should not be allowed to make alterations to the property. And if there are alterations that are important, then that should be done with the landlord's permission. There's also the issue of assigning or subletting. The landlord would want to know, and in many instances may not allow the subletting of the property. But in instances where subletting is allowed, it should be done with the prior consent of the landlord. And so those are some of the very important covenants. Also, there's a covenant as to nuisance. So the tenant must occupy the property without creating nuisance, without creating annoyance or inconvenience or any disturbance that could affect neighbors. And so that's also a very important covenant as it relates to the tenant. In advising a landlord, I'd also want to make sure that they get some indemnification for personal injury. So if for some reason the tenant, while in occupation, suffers an injury, then we would want to know that the landlord is not responsible for any claim that could arise for that injury. So we would want to include that in the lease as well. And so those are some of the things that are the obligations of the tenant, that the tenant will covenant to the landlord, that they will warrant or provide some level of responsibility or assurance that they will undertake to do these things. We also have the landlord's covenants. So as someone advising the tenant, I would want to make sure that the landlord has covenanted to do certain things and the landlord has undertaken certain obligations, such as paying taxes, paying the property taxes, paying any tax that may be due on rent. Also, covenanting to provide quiet enjoyment, to allow the tenant to peaceably occupy the premises, and we spoke about that a short while ago. Also to repair, to do certain repairs, and as I said before, a landlord may want to put a certain minimum sum on repairs, and so repairs over a certain sum. The landlord would also want to covenant that the property is insured, and so that while you're in occupation as a tenant, the premises are insured against, loss that may occur by damage or fire or earthquake or flood. The covenants, therefore, keep both parties honoring their obligations under the lease. And where we have these obligations set prior to occupation, there will be, the less incidents of disagreements occurring throughout the term of the lease. Another thing we want to see is the possibility of the tenant maybe having the ability to purchase the property in the event that the landlord decides to sell. And so we would want to advise our tenant to request a right for first refusal or an option to purchase provision in the agreement. And that is also very important. One of the things we like to advise our clients, in particular landlords, is that this option should be their option, not the tenant's option. Because if the tenant has this option, then it could lead to the landlord forcibly having to give the tenant that option. So it should be the landlord's option. There should also be an option to renew the lease. So if the lease is a 1-year lease, the tenant may want to know that at the end of 1 year, they have the option to enter into a new lease for the same term or for an increased term. And so that's also a very important covenant we would want to include in the lease. Another important covenant, and I'm going to break here so that you can ask some questions, is there should be a holding over provision. So the lease speaks to the term, which is typically 1 or 2 or 3 years. But what happens at the end of a term if the tenant remains in possession? And under the common law, if tenant remains in possession at the end of the term, they remain as a monthly tenant. And so it's important as well that we speak to holding over. I said this would be my last point, but another very important point is termination. The lease should have a termination provision. I've seen many leases where prior to the end of the lease, the tenant wants, for some reason, to exit the lease, but the lease does not speak to termination. And so under the law, the expectation is that the lease must run to the end of the term. And so if for some reason the tenant needs to exit that lease, there may be an obligation to pay out the landlord for the term remaining in the lease. So, Paulette, those are some of the key points.
Right. So do these covenants apply to commercial properties, or is that a different ballgame altogether?
Both commercial and residential leases will typically have the same covenants.
Right.
Yes.
Okay. So when we talk about maintenance, I've seen a lease where the landlord has said the tenant is responsible for the servicing of the AC. In other words, they have to pay for it obviously, and do that on an annual basis and show them a receipt. Can a tenant say, I don't want that responsibility?
Tenant could, but a lot of what goes into a lease, as long as it's reasonable and determined by the courts as being reasonable, can be agreed between the parties. And in that instance, it generally comes down to where the market is for rentals. And so, if there's more demand for rentals than supply, the landlord tends to be in a better position to dictate the terms. There's certainly in our jurisdiction, it's not always typical that an apartment or a house may be supplied with an air conditioning unit. So, the landlord may be saying, I really don't have an obligation to provide an air conditioning unit, but the property already has one. It's going to be your responsibility to service that unit. In commercial premises, there is really, in practice, no obligation to provide air conditioning. And so a commercial landlord may just provide 4 walls, and the tenant may be responsible for installing the air conditioning and maintaining it. And of course, when giving up occupation, would remove the air conditioning.
Okay, so the other thing I would like to talk about in my almost daily experience is what's becoming more and more common is tenants who knows that the property is being sold, who are making it more and more difficult for the property to be showed. But what does the landlord do? We know already that they're not supposed to change the law, cut off the water or anything like that, but what is the best advice to give to a landlord in those situations, especially now where it's coming up more and more? What can they do beforehand?
Well, what needs to be done is that the lease needs to speak specifically to that. So
Right.
there would be an obligation under the tenant's covenants to provide re-entry to the landlord. And re-entry, as I said before, can be to undertake repairs, or it may be to show the property. So that provision or clause in a lease agreement should specifically state whether the landlord must give 24 hours notice, must give 2 or 3 days notice, whatever is considered reasonable to allow inspection or the showing of the property. It may specify the days of the week, the landlord and the tenant could agree.
Right. Okay. Another question. You spoke about if the tenant wants to be given first preference to purchase, do they do that? Is it always good to do that at the first lease, or if you've lived in it for a little while, by second year you're thinking, yeah, I'd like to buy this. Can I approach the landlord about doing that? When is always the best time to do that?
Once you sign that first lease,
Okay.
if you're in a transient, if your circumstances are transient, so you're expat,
Yes.
you're working and you're on a 2 or 3 year contract, then it may not be required. But if you're someone looking some stability, and you don't want to be moving in and out of rented premises, and you enter into a 2 or 3 year lease, you may at some point want to consider ownership. Then it takes very little effort to include that provision in the lease.
So another question would be then, it seems like you've got to get things, it depends on where you're at, but you really have to think this thing through in terms of where you think you're going in the next year or 2 years. So if I signed a lease, if a prospective tenant signed a lease, a rental, let's say, for 3 years at a set amount, rental amount, does that mean the landlord cannot then come and say in year 2 that I want to increase the rent? Is it that you pay because you signed to a 3-year rental agreement for $1,000 per month? The landlord could not come to me in year 2 and say, I want to put up the rent by 7.5%.
Well, he may, but as we know, the lease is a contract, and if contractually it has been expressed that you're bound to pay a fixed sum over 3 years, then any request outside of that would be a breach of those express terms. So the landlord would be breaching the terms of the lease.
All right. And then we talked about nuisance. Does that apply to both sides? So can the landlord be a nuisance to the tenant?
No, absolutely. Absolutely. So in that lease, the obligation goes on both sides. So one of the tenant's obligations is to honor quiet enjoyment and to limit nuisance, so the neighbors aren't affected, because the neighbors can institute a claim against the landlord for nuisance or any activity of nuisance or element of nuisance that takes place on his property. So the landlord wants to know that the tenant has covenanted to providing or limiting or not being involved in any nuisance activity. On the other hand, there's a covenant, or should be a covenant, for the landlord to allow the tenant to peaceably enjoy and remain in occupation. So it's an obligation on both parts. And as I said before, the leasehold interest suspends the landlord's freehold interest. So not because you're on title means you can stop by the property every day and harass the tenant, or you want to come in and look to see whether the walls are, are in the same color. You really have no legal basis for coming into the property except for those instances outlined.
Right. So a landlord basically can't have a spare key and enter the property when they feel like it.
No, a landlord would be a trespasser.
Good. I've heard of those stories. What about where a landlord rents let's say, a 2-bedroom apartment, but they want to lock off one of the bedrooms so that the renter only has access to that 1 bedroom and the rest of the house, but they want to keep a room where they lock things away? Because I've seen that a few times.
Well, that would have to be done by agreement. And so if this room does not have an external entry point, and the landlord, to gain entry, will have to walk through, the other areas of the property, then that has to be done by agreement. And for that reason, that agreement ought to be in writing so that there is no misunderstanding. And so this concession would be provided by the tenant and should be agreed by both parties what the boundaries are. So we wouldn't expect the landlord trekking in every morning to,
come and pick something up out the spare room.
Yes.
Yes. Yeah. So, well, I'm hoping that I've asked all the questions that our listeners would be thinking about. But we are asking people to subscribe to this program and to share with their friends and just keep on asking us questions. That's what's really going to keep the program going. And we really, as we say at the beginning and the end, or somewhere in the show, always work with the professionals. Because a lot of the time what people do is ask their friend. And what happens is they don't realize that their friend's experience, the background to their story, is going to be slightly different or completely different. And they just think that they can do whatever they want to do. We also know that we have a lot more bad behaving tenants. So I'm just wondering, what else? I mean, already people think that the laws it's perceived that the laws are mainly on the tenant side and not on the landlord's side. But I think the covenant should cover everything. But sometimes, each party finds a little way to adjust things.
There'll always be disagreement, but back to your earlier point, I think what's very important for a landlord is having a quality tenant. So if for some reason an issue arises that may not fall within the ambit of the lease, both parties can work in an amicable way. And many times persons, and I've seen this in my own experience, try to rent properties on their own and don't have the wherewithal to undertake the screening process and qualifying process that mitigates a lot of these issues. So I think back to that point it's like now a cliche for us. Use a professional. A realtor will take steps to screen that tenant, get proper references so that from the front end, from the onset, you're minimizing some of the issues that could come with that landlord-tenant relationship.
Yeah. And what I have realized as well over the years is that the landlords who choose to rent properties on their own are beginning to realize that they do need to do more due diligence. So I used to see where people would see an advert in the paper, go to the landlord, look at the property and hand over their money. And the landlord doesn't really know anything about the tenant and vice versa. And then in a month or two, they're renting again. So I'm hearing now that landlords are even asking for IDs and a reference even, which I think is a much better thing to do because that wasn't being done before. And maybe they're learning from us, but obviously they're not going to be asking for all the poker documents that you and I have to ask our clients for before we can do business with them. But I'm hoping that there'll be some...
Sorry.
So the other thing as well, I think, comes to question is properties that are falling apart while the tenant is living there. I mean, is there, what can we do about that in terms of the agreement. So when you sign, before you sign that lease, how can you put something, have something in that makes that landlord think about that? You know, you can have a leaky roof. I mean, I've you know, tenants I've got calling me saying they're looking for somewhere because, you know, the roof is leaking, and I've told the landlord, and they say next month. I have another one where a lady said she's going to be leaving, but she knows she's not going to get her security deposit back. This lady never has any money. She's got a leaking bath, and it's going to go. She's saying, oh, the tenant must sort it out and she'll pay her back, but she's not sure she's really going to get her money back. So what kind of things can the tenant request to go in the lease agreement? Because like I said, people, it's not when it's all good that you've got to...
The lease should have a clause that speaks to the landlord's obligation to keep the property in good repair.
Yes.
And so, you know, there may be minor issues. You know, the kitchen faucet needs a washer.
Yeah.
You know, the cost is $1,000 or $2,000. The landlord may say anything over $10,000 will be for
so you cover that.
will be for your account,
Yeah.
but anything major ought to be. So I think the lesson is the process of qualifying should not just be on the landlord's part, but a tenant should also make sure that, you know, the landlord has a standing to or demonstrates a standing to honor the obligations in the lease.
Yeah. Okay. I think I've covered everything.
I think you have, Paulette.
If I've missed anything, I know you're going to tell me.
You have, and I'm sure, you know, we can have our viewers or listeners send questions in, and we can address them in another program.
Yeah, because that's beginning to happen, which I'm liking. So, you know.
Very good.
Onwards. Oh, yes.
Very good. So good to be in the recipient seat and not be asking the question.
Okay.
All right.
So until the next time, listeners, take good care. Stay safe.
Take care. Bye-bye.
Bye for now.
Oh la 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 la. Bamba.